So good morning, good evening, good afternoon, everyone, and a very warm welcome, or should I say welcome back to this SIEL conversation on the screening of investment activities in international investment law. My name is Maria-Laura Marceddu, and I am the executive co-treasurer of the Society of International Economic Law. Although today I'm here in a different capacity, since I have the pleasure of being the chair for this panel with such a stellar lineup of speakers. So a very warm welcome from all of us to those attending this webinar. Now, before starting the discussion on the screening mechanism in international investment law, I just have a couple of announcements to pass on to you from SIEL. The first one is about the annual general meeting, which is scheduled for December the 7th, so mark your calendars. Also remember that in the course of that AGM, there's going to be elections because we have a number of vacancies in the council to fill. So this is also to encourage you to become a member, not just to take part in the election, but also to join, of course, our community of international economic law minded people. The second announcement is to invite you to the next conversation that will take place on the 28th of November. And that will be about the China's Belt and Road Initiative, a new model for transnational governance. I think I might also share the link with those attending in the chat. Otherwise, keep an eye on our website and you will find the relevant informations. If you have future ideas for possible SIEL conversations, please feel free to get in touch with the SIEL Vice President. So that would be Isabel Van Dam or Marcus Wagner. Or you can also get in touch with Geraldo Vidigal, who has been taking care of this conversation for the last year. Or you can also drop me a message. Now, just a second. Okay. This conversation is going to be recorded, and the video will be available on our YouTube channel shortly after today. Please subscribe to our channel if you haven't done so, and also remember that we have uploaded many videos from the SIEL 2023. So if you weren't in Bogota for the biennial, have a look at the YouTube channel and you can catch up with what you missed. I think that's all from the SIEL side about this conversation. There is a Q&A box, so you can submit your questions also anonymously if you wish, and the panelists will be happy to answer them either in the course of the conversation or perhaps at the very end. Now, without further ado, I think it's time for me to introduce the speakers. I will start with Professor Sarah Bauerle Danzman, who is associate professor at Indiana University, Bloomington, and for this year also a resident at the Atlantic Council Geoeconomic Center. So welcome, Sarah, and thank you for having accepted our invitation. Then we have Agata Daszko, who is research fellow at the University of Göttingen and also consultant at the Trade in Service Division at the OECD. And I must say that she and Kilian are also the driving force behind this panel. So it's thanks to them if this panel has been put together. So thank you and welcome to this conversation. Then we have Ksenia Polonskaya, who is assistant professor at Carleton University. Welcome, Ksenia. And lastly, last but not least, we have Kilian Wagner, who is researcher and assistant lecturer at the University of Vienna. So thank you, and thank you to all of you for having accepted our invitation, and welcome. Now, moving on to the topic, it's no secret that security, it's an issue that has been taken stage in the last few years, has gained significant prominence. And in the context of international investment law, security has been instrumental, I would say, to build walls in respect to incoming foreign investment, which, because of the presence of this mechanism, are now granted access only if certain requirements are met. The number of countries that have set up or stepped up their national security-based policy is growing. And among those we have, for example, Australia, China, Nigeria, Sri Lanka, the United States, the European Union, Nigeria, and many more. And the rules, since this phenomenon is gaining prominence, so are the rules set for regulating this area. And as are the tension that are growing between a negative decision issued by an investment screening mechanism and the potential impact it might have, this decision might have on investment protection. So the general idea for this panel is to discuss this phenomenon through what have been so far the major legal and political challenges associated with screening mechanism related to the foreign direct investment and the obligation of state as voluntarily committed to protect investment via international investment agreement, or more broadly under international investment law. Now, the question would be, are these investment screening mechanisms just about security? A little spoiler, the answer is no, there's much more. But I think to start the discussion, it would be nice to first set some historical and policy boundaries of national security related investment screening. And to this end, I'm going to give the floor to Sarah, and then I'll give the floor to Agata. So Sarah, you have the floor.
Well, thank you very much, Maria, and thank you to all of the panelists, particularly Agata and Kilian, for organizing us, and thank you all to the attendees. I will start with a very, very quick and brief overview of kind of thinking about these investment screening mechanisms from a more historical perspective. Of course, we all know that investment screening is nothing new, and it has been around for a long time. Many countries, while they still had much more stringent regulation on investment generally, also had some form of investment screening, normally to determine economic benefits of inbound investment. And during the period of time in which countries transitioned to more liberal investment environments, many of those screening mechanisms were taken away. However, since 1975, the US has had a kind of, until recently, very small investment screening process, as well as a few other countries. Australia also stands out here as a country that has used investment screening specifically for national security purposes for a long time. What's new here is that there has been in recent years a growth in investment screening mechanisms that are much more focused on interventions due to national security or essential security concerns. In the European context, this is oftentimes framed as public order. We see that these mechanisms have grown since the mid-2000s, but in particular, they have rapidly expanded over the last 10 years or so, or even over a kind of more compressed time period. In work that I've done with Sophie Meunier on this, we have focused on qualitative coding of investment screening mechanisms across OECD countries, and we see that basically the number of mechanisms have doubled in recent years, as well as they've become more stringent. I will say that there continue to be some holdouts among OECD countries in terms of countries that continue to decline to use investment screening mechanisms. But those tend to be like the Latin American countries in the OECD, still do not have investment screening mechanisms, or at least ones that we code as investment screening mechanisms. Although they are thinking about putting some in place, a lot of this kind of growth has come from European OECD countries, and that has largely been driven by the EU's investment screening regulation. In terms of what we see in trends, both in terms of new investment screening mechanisms as well as the changes to existing regulations to make them stricter, I'll say that there are kind of three things that I want to emphasize here. The first is that sectoral coverage has really expanded in recent years. Of course, there's differences across countries in terms of whether they have cross-sectoral mechanisms or if they have sector-specific mechanisms. But regardless, we see that countries are expanding the types of industries and types of business activities that they view as potentially related to national security concerns. In the past, these mechanisms have mostly been focused on protecting the national defense industrial base. And then in the mid-2000s, there was more of an emphasis on critical infrastructure. Now, not only are those two original concerns still part of the decision-making process, but there's a lot more emphasis on critical technologies and sensitive personal data, as well as, in some countries, critical supply chains. The other thing is that the mechanisms have lowered thresholds pretty substantially in terms of the size or the economic benefit or the beneficial ownership of an investment that would be covered. Most investment screening mechanisms still continue to be focused on cross-border mergers and acquisitions, although there are a few that also cover greenfield investment. But the size of the investment as a percentage of ownership is required to trigger a transaction has been lowered substantially in recent years. Just 15 years ago, if a country even had an investment screening mechanism, it might not look at a transaction unless it entailed a majority stake in a local business. Now, many countries have lowered that threshold to about 10%. And in some countries, for some types of transactions, even kind of lower investments that are lower than 10% are also covered. And finally, while we do see some policy convergence in terms of the types of industries that are explicitly covered or that the governments focus on in their reviews, that has converged, as well as this kind of convergence of having lower thresholds for review. There continue to be important differences across countries in terms of how they actually structure their investment screening mechanism and implement it. So it's not as if every country is moving toward a kind of clear best practice. There's a lot of variation in terms of who within the government is engaged in reviewing transactions, whether that review happens within the context of a specific ministry or in a cross-ministerial structure, how, if at all, mitigation is considered, as well as whether the investment is kind of required to, whether there's a standstill agreement in terms of investment not being allowed to go through before a clearance or not. So a lot of expansion in similar directions, but continued variation in terms of how screening is implemented.
Thank you very much for this short also introduction to the topic. So I think one may wonder at this point, well, security is generally what these investment screening mechanisms are associated with, but is there more? Are there any other ideas associated with this type of mechanism? And I think Agata has something to say on that regard. Agata, you have the floor.
Thank you, Maria Laura. Yes, of course, ideas, there are plenty. In my research, I came across various ways in which environmental considerations can be conceptualized in terms of FDI screening. And I think the three main categories, which I think fit well with today's topic, would be looking at environmental considerations as security considerations, looking at them as policy considerations, and looking at them as domestic legal considerations. So just very briefly looking at them through the security lens, for many of us, especially here in the EU, FDI screening is indeed associated with security. It just so happened that the European Commission issued its newest report on the FDI screening just yesterday, underpinning how it helps to underpin European security. It also highlighted that since the regulation came into place, the number of EU member states with a screening mechanism has grown from 11 to 21. As Sarah outlined, whether they are sector-specific or across or multi-sectors, those screening mechanisms are having a huge impact on trade and services and on investment. And whether the environmental sector is one of them really depends on the state's reading of the regulation and how this regulation is structured in the national laws. And especially Article 4.1c of the regulation, which dictates that in determining whether the FDI is likely to affect security or public order, member states and the Commission may consider its potential effect on, and here it is, on the supply of critical inputs, including energy or raw materials, as well as food security. Now, it is not outside the realm of possibility that an investment, for example, in construction, that is to take place around groundwater, agricultural land, or have a negative impact on biodiversity, may have an impact on, for example, food security. There are, however, several drawbacks of such conceptualization, not least vis-a-vis protectionism, heightened bureaucracy, and perhaps playing down what others would consider to be real security concerns. Moving on to environmental considerations as policy considerations. So looking at it through the policy lens, here we could refer to the United Nations Sustainable Development Goals and the well-known but perhaps less regarded environmental, social, and governance, so ESG factors and corporate social responsibility. I came across a great paper by Cibalcati from 2021 in which the authors say that ESG factors and international global transfers has largely been studied in the context of portfolio investments and mainly at the firm level. The authors then went on to have a look at it from the state level. And so having a look at how, if at all, ESG have an impact on FDI flows, and having studied 161 countries, they concluded that no FDI inflows to countries are associated with standard economic factors, such as domestic investments, climate, per capita GDP growth, and trade openness. Climate risk does not deter FDI, and that there is no association between FDI and carbon emissions and sustainable reporting. What the paper does not look into, and well, I haven't looked anywhere, haven't found anywhere else, is where there is indeed, and where there's only anecdotal evidence, is whether states would then turn down investment or screen it based on the state's own commitments to ESG factors or to SDG goals. However, one could now say that with the increase of successful climate change litigations we are witnessing, states might have to start considering this policy lens more thoroughly. And finally, and I will be very quick on this category because it is also my current research, so you can just skip through it. I will develop it slightly further later. We have environmental consideration as domestic legal considerations. And here I would highlight something that I also would say is nothing new. And that is the well-rooted mechanism of environmental impact assessments. After all, any project, whether domestic, international, And so far, all jurisdictions I have been looking into needs to go through some sort of environmental impact assessment process. There are, of course, many issues with this domestic lens, not least how, if at all, it compares to states' international responsibilities. But in any case, I would argue that environmental impact assessments are not only an essential element in the aspirations towards sustainability, but could be seen as paramount to the implementation of international environmental law on the domestic level, even when, as confirmed by case law, their precise nature, level of obligation and scope do remain elusive.
Thank you. So also thank you for mentioning that there are areas that, according to your findings, where investment screening finds no connection at all. You mentioned, for example, carbon emission areas and that field. So the next question, and this would be for Kilian and Ksenia, is to understand whether what are the not so commonly, the least associated ideas that are still gaining prominence and still relevant in the discussion about investment screening mechanisms. So leaving, I would say, security and to a certain extent, environment aside, are there any ideas that were somehow in the background and now they are gaining prominence in the context of screening mechanism, especially as far as foreign direct investment screening under international investment law are concerned? So I'll give the floor to Kilian and then to Ksenia, who will have some interesting answers to this point.
All right. So first of all, thank you very much for the SIEL and my co-panelists to setting this up today. I will now try to contextualize investment screening for national security risks in the context of international investment law. And as I think the outline and historical overview has clearly shown, is that FDI screening mechanisms for security reasons can clearly have a restrictive effect for foreign investments. The EU, in its FDI screening regulation, defines investment screening mechanisms as an instrument to assess, investigate, authorize, prohibit, or even unwind foreign direct investments on grounds of security or public order. So this inevitably raises the question of the compatibility of screening laws and decisions taken thereunder with the state's obligations under international investment law, included in bilateral investment treaties, but also in investment chapters in free trade agreements, such as national treatment, most favored nation treatment, the fair and equitable treatment of investments, or also the rules on expropriation. And moreover, so these treaties, of course, include the option for investor-state arbitration, and this also concerns the question whether foreign investors could base a claim for compensation against the state with respect to negative screening decisions or restrictive measures taken under screening laws. And to answer this question and to contextualize that, I would say that both a look at the scope of investment treaties as well as the investment screening laws and the screening situations would be necessary. To start with the scope of investment treaties in this regard, in principle, there's a broad distinction between those investment treaties which only protect the so-called post-establishment phase, and this concerns the vast majority of treaties. Mostly the treaties by European states do follow this model. These only protect existing investments which have been admitted in accordance with the host state law, transactions which have been concluded, businesses which have been established. These treaties still require the state to establish favorable conditions for foreign investments. Nevertheless, these clauses included in investment treaties are not enforceable via investor-state arbitration. And on the other hand, we have treaties mostly concluded by the US, by Canada, or by Japan, but also we find that in regional free trade agreements concluded recently, such as the CETA or USMCA, which do extend investment protection to the so-called pre-establishment phase and to some extent the making of investments via making of an establishment or an acquisition of an investment. And those treaties extend national treatment and most favored nation treatment to this pre-establishment phase. But we also see that no state is willing to extend investment protection to the pre-establishment phase to all kind of sectors or all kind of industries. So also these states have excluded certain sensible sectors or industries from the scope of these extended investment protection provisions, or even also screening laws from the scope of those provisions. Nevertheless, there might be scope for tensions with screening laws and such treaties in this regard. If we have a look at the scope of screening laws, we can also clearly see in the past couple of years an extension, as Sarah has pointed out, towards more sectors are undergoing screening. We can also see that in recently adopted or modernized screening laws, investment expansions can be subject to screening mechanisms, such as the acquisition of further shares in a company, which leads to the taking over of control in a company, or even forms of retrospective screenings, such as call-in screenings, where a pre-notification requirement, for instance, only applies to certain sectors, such as screening legislation. Some of them do allow the state to initiate ex officio screening proceedings for other sectors, which do not require pre-notification. And in those instances, we might actually have an existing investment already when a transaction is undergoing screening, which could be more problematic under both types of treaties, those which only protect the pre-establishment phase, but also those which only protect the post-establishment phase. And that such tensions are possible, and foreign investors are already exploring investor-state arbitration as a potential legal remedy on the international level. Becomes also clear there's already one ISDS proceeding, or publicly known ISDS proceeding, Global Telecom versus Canada, which concerns the prohibition of an, let's say, investment expansion under the Investment Canada Act. The claims have eventually been dismissed by an arbitral tribunal. Nevertheless, it shows that a tribunal may have jurisdiction to rule over such a dispute. And moreover, there's another ISDS proceeding, Huawei against Sweden, which concerns the alleged exclusion of Huawei's equipment from the 5G rollout. It's not particularly concerns investment screening, but investment control measures for security reasons in a broader sense. So this clearly shows that investors are exploring these potential legal remedies on the international level with respect to restrictive measures adopted under screening laws or other laws.
Thank you. It seems there's already some kind of trouble with this mechanism and its interaction with international investment law. And I think more trouble is on its way. And I'll give the floor to Ksenia.
Apologies, I have to actually turn on my mic so you guys can hear me. But thank you very much, everyone. I appreciate all the wonderful interventions, and thank you to Agata and Kilian, of course, for putting this panel together. It's been fantastic. And I think I'd like to echo, I guess, all of the speakers and bring some more trouble in a sense, because fundamentally, whenever we speak about investment screening, we talk about mostly national security. And now we have some kind of push to talk more essentially about environmental measures. But there are certain other things that we have to think about whenever we speak about investment screening. And some of those things are not necessarily environmental per se, but we can frame them as sustainability issues that have to be brought into light. And when I speak about sustainability, I mean not only environmental, but also social aspects of sustainability. But also specifically so, I'd like to emphasize indigenous rights in this context. And specifically so, with indigenous rights, it has been an extremely prominent topic in the context of international investment law, as probably all our listeners know. But essentially the problem there is that there's so many investment projects that occur on traditionally indigenous lands or sacred lands of indigenous peoples. However, whenever we talk about those issues, we almost always reduce to the conversation and the framework of the whole state law. And that's where we have to think about the screening process, right? But should the screening process exist continue to exist only at the domestic level, where we know that certain countries can be more susceptible to particular lobbying from foreign investors or any kind of private arrangements that can be made, or certain governments can be completely disregarding their responsibilities towards indigenous peoples, because there is a race to the bottom incentive to actually attract foreign investments and for the investors to actually establish their projects there. So it's quite a complicated conversation, right? Or should we think about the screening process for protecting indigenous rights through the screening of investments mechanisms also at the international level? And those are very fundamental choices that, well, states, the policymakers, in my view, have to make. When I would speak, I'd like to emphasize this. When I would speak about investment screening, it's a conversation about access, right? Who can have access to what? And it's a conversation about access from two perspectives: and access to the jurisdiction to actually establish an investment project, but also an access to, well, dispute resolution mechanism, right? So what kinds of investments should be eligible for the international protection under, for example, ISDS? Under what circumstances the tribunals have to establish jurisdiction to protect certain types of investments, and perhaps certain types of investments that engage indigenous communities or, for example, occur at the traditionally indigenous lands, well, they should be subject to more specific screening requirements. And that's something that states and policymakers have to have a very careful thinking, also conversation about. And that's not what's happening, as we all know, at least not under the current reform agenda at UNCITRAL, but perhaps it's something that can happen at the sort of bilateral level conversations. Specifically, so I think it's important in certain contexts, specifically so in the Canadian context, I think, because Canada, well, has responsibilities towards its indigenous people, specifically so fiduciary duties towards its indigenous population. So there's certain constitutional requirements that the government must satisfy. So I think that kind of invites a very interesting interplay in the conversation with the investment law, constitutional law interface. And specifically so, I think it ironically manifests in this very, very, you can say, procedural discussion on a screening of the investment projects. But I've always been a proponent of the idea that you can't really divorce procedure from substance. The UNCITRAL working group disagreed with me. They did that. So I'll be pushing my own agenda here at the great webinars put by Kilian, Agata, and the Society for International Economic Law. Thank you very much.
Well, thank you, Ksenia. Well, I don't know if there's anyone in the audience from UNCITRAL, so you'll never know what kind of spillover effect this might generate. Anyway, so I think I'll pick up on this point, because I tend to agree with you when it comes to being extremely focused just on the procedure, because at that point, one might even wonder if we really need a mechanism of this sort, especially consider that to a certain extent, the international investment law regime is already framed by geoeconomic, environmental, and to a lesser extent, human rights considerations. So what would be, in the end, the added value of an instrument like a screening mechanism? And I think we can start with Kilian, and then Sarah, and then Agata, and then Ksenia.
Yes, thank you very much. Yeah, I would also tend to say that the investment law regime, to some extent, is framed or allows to take into account geoeconomic developments and also concerns, since there might be certain tensions, which I've outlined before, and also already proceedings ongoing in this regard. Nevertheless, foreign investors would also face major obstacles, since there are safeguard mechanisms which states can include in their treaties. In this regard, carve-outs or reservations are often discussed, or so-called security exception clauses. In this context, I would draw a distinction within international economic law between trade and investment law, since we do find security exception clauses in the GATS, and the TRIPS agreement under WTO law, history of which and the extent of which and whether it's self-judging or not might be disputed. Nevertheless, it is there. For investment treaties, it will be required to have a look in the individual treaty, which is applicable. And it's especially those classic bilateral investment treaties concluded in the 1990s, where we rarely find security exception clauses or any other kind of policy exception clauses. Under the UNCTAD Investment Policy Hub, which maps bilateral investment treaties, it's around 400 out of 2,500 treaties, which actually include security exception clauses. More modern treaties, CETA, USMCA, or other modern, especially other treaties concluded by bilateral treaties concluded by Canada, do include security exception clauses. But what might be another problem here is the notion of security pursued by states with domestic screening policies and the notion of security on the international level. Let's say, so arbitral tribunals have applied security exception clauses in a certain number of cases, which mostly relate to the Argentine financial crisis of 2001, 2002. And the case law on that was initially quite inconsistent. And while arbitral tribunals in investor-state dispute proceedings have agreed that a severe economic and financial crisis might amount to a security risk of the state, even though most tribunals have not accepted Argentina's invocation of the security exception clause because they have applied a very narrow reading to the nexus requirement. The measure needs to be necessary to protect security interests. Have rather read the only way requirement from the state of necessity and their customary international law into the security exception clause. So there might be certain limits for the application and availability of security exception clause. It's mostly states which argue that security exceptions are fully self-judging, but up to today, it has such a fully self-judging effect has not been accepted by any panel established under the dispute settlement body of the WTO or by any arbitral tribunal. And apart from security exception clauses, and for those many treaties which actually do not include one, the question arises how security interests might be considered in dispute settlement. And arbitral tribunals in ISDS have well accepted policy objectives of a certain measure of a state in interpreting and applying the national treatment standard, the fair and equitable treatment standard, but also in determining whether a measure constitutes an indirect expropriation or is an uncompensable regulatory measure. And also in the proceeding which I've referred to before, Global Telecom versus Canada, which concerns the prohibition of an investment expansion under the Investment Canada Act. So the BAT is the BAT between Canada and Egypt from the 1990s. It does not include a security exception clause. But in the assessment, so Global Telecom has alleged that Canada has subjected its investment to an arbitrary, non-transparent security review and has failed to meet due process requirements. Nevertheless, the arbitral tribunal, in assessing whether this security review and how it was applied actually violated the FET obligation under the BIT, it took into account Canada's security interests and also held that the due process requirement is complied with if the investor can bring its case, the right to be heard is accepted, and a administrative decision is being made on objectively verifiable factors. So the tribunal has large parts of this award are redacted due to the sensitive information included, I assume. Nevertheless, the tribunal has eventually dismissed the claim and very much considered Canada's security interests as well. So I would say also, if there's no explicit instrument included in the treaty, it's still possible in dispute settlement and in assessing whether a state has complied with its obligations or not to take into account the state's security interests in this regard.
Maria, did you want me to go next? Okay, great. So I'm going to approach this question from a slightly different perspective, which is what is the, to what extent are investment screening mechanisms even like necessary, or to what extent do they add value? And I think that it's important to recognize that, at least in the US case, where, and it is true that the US is engaging in a lot of bilateral and multilateral discussions around how to develop best practices around investment screening. There's a heavy emphasis on the idea that investment screening should be a tool of last resort. So when we think about different sets of issues that might be problematic from the perspective of an investment, including environmental concerns, I would say data security concerns, human rights concerns, etc. When it's the case that regulations should be applied equally between domestic firms and foreign investors, because the issues persist, regardless of the nationality of the investor, I think that those are indications that those types of issues are probably not well suited for an investment screening mechanism, but instead should be addressed through domestic regulatory practices. On the flip side of that, for national security considerations, where there really is a legitimate national security concern about who owns a particular asset or a particular technology, or has control over a particular critical infrastructure or so forth, there is legitimate reason why governments want to be able to make sure that they do not allow, in the context of an open investment environment, for threat actors to gain control over those assets. And so I think in that context, we can interpret investment screening mechanisms as tools that are there to try to keep the investment environment broadly open, right? Because the other way that you would deal with this issue is by just reserving particular sectors for domestic investors and prohibiting outright foreign investment in those sectors. An investment screening mechanism approach instead allows for case-by-case review to determine which are the investments that really are problematic from a national security perspective, and to prohibit or mitigate only those. Now, of course, we can talk about the extent to which determinations around national security and public interest could expand in ways that move from being kind of narrow to broad, and that is certainly a concern. But at least from from a perspective of determining, what is appropriate and what is not in the context of investment screening, I do think that it is useful for us to imagine the alternative, which would be just flat out prohibitions.
I will go next, even though I have a lot of questions to Sarah. But I think from the environmental perspective, the added value of having explicit environmental considerations in any sort of mechanisms, that it might be whatever we call it, is just the reinforcements of those considerations. What Ksenia has said about framing something as sustainability, or framing, we see it quite a lot happening in the case law, where environment is framed as something that can fall under something else. And here I would perhaps take a step back to what you, Maria Laura, said about how far environmental considerations frame international investment law at all. And again, I would perhaps make three observations, which is one is on investment, one is on investment law, and one is on investment arbitration. And with sort of the question of investment, and drawing back to my previous proposition, environmental considerations do affect FDI, especially if we consider environmental impact assessments, which the domestic regulatory practices that Sarah has spoken about. EIA process, wherever you look, it's the sort of jewel in the crown of the principle of prevention, integral component of sound decision making. But no one really knows what it is. So there is still a question of the nexus between EIAs and the likes of due diligence, principle of prevention, precautionary principle. There is a huge scope under public international law, 2015 certain activities on the scope for variation in the way that states conduct the assessment. And then there are more questions than answers when we look into international law, and one of them refers to how far beyond the immediate impact of the project should the assessments go. So, for example, you have the scope 1, 2, and 3 of the greenhouse gas emission in mining and oil industries. And after all, if environmental considerations were to guide state policy, I would argue we would see far fewer states welcoming, incentivizing, and exploring investment in fossil fuels in 2023. And then moving to international investment law, I would echo what Kilian said about treaty language. How far do environmental considerations frame the law? Well, the law doesn't allow for a free-for-all. Most agreements do have some sort of legality clauses, language regarding police powers, that do consider public policy based on at least health, again, into which environment can be sort of read into. Most problems that we do run into occur when such language is missing from the treaties or the applicable arbitration rules as well. So here I would look into case law, Cortec mining and Kenya, which where even though there was lack of an explicit legality clause, the tribunal found that both the ICSID Convention and the BIT only protected lawful investments. What made the investment unlawful in the case was the fact that the investors did not comply with the national requirement of environmental impact assessment. Now, before moving on to the ISDS very quickly, I would observe that while environmental considerations might not have shaped international investment law to the fullest extent, but rather influence some of the ideas, they are beginning to do so now. So the considerations do go in now, as can be seen with the conclusion of new treaties, with modernization of some other. And finally, how far do these considerations frame international investment arbitration? Well, depending on who you ask, it's either somewhere between not at all and wholly. There are considerations on there are voices on both sides. Studies have shown, that there are at least 170, 180 investment clades with environmental components. Now, intuitively, we would also say that environmental arguments would follow, but there are other studies that show that despite environmental components, the environmental arguments are not being made. They play a minimal role in these proceedings, especially under the ECT, but not only. And in reality, and perhaps it is an unpopular observation, these environmental arguments, with the exception of some claims in South American context, but these are still also ongoing, those arguments are largely untested. States rarely stand up in front of tribunals and say, look at us, we are so committed to saving the planet that we have made this and that regulation, because that opens them to some arguments on the national level. So states are also being sued in domestic through litigation. I would argue this is changing. I would argue looking at case law happening right now, publicly available memorials in RWE and the Netherlands show that this is changing. Eco Oro, great case, still ongoing regarding the monetary valuation. Which I don't think we should be throwing the towel in just yet on how bad or how good that case was. And then you have case law happening here in Europe, case law involving Slovak Republic, where the tribunal, the majority did say that the vital importance of non-renewable resources cannot be overstated, especially in the era of alarming climate change. This is to do with an investment in water resources, which the tribunal did not give any considerations to sort of legitimate expectations of the claimants in that case. So I think first, sort of coming back to my opening statement, it's to do with stopping to frame environment as something that is not something that can fall under the language of the treaties, and actually including it in the treaties, making the life of tribunals slightly easier in a way. So sorry, that would be it from me.
Yeah, I presume that I can make an intervention now, and I appreciated sort of the two different perspectives that Sarah and Agata bring to the table, in a sense, because whenever we speak about the idea of investment screening mechanisms added value, I think we always have to think also about those two kind of broader perspectives, whether we care about mostly investment liberalization and we should continue kind of draft the agreements like we did, the governments did in the 1990s, or we care about something else. Well, the problem of the language in the agreements that we can see now is that it's true, it's very difficult sometimes for the tribunals to make a strong interpretive case that environment, sustainability, other concerns should matter. And it's in a way convenient sometimes to say, well, we have this provision almost in all agreements that investments must comply with host state rules and regulations. Well, too bad. Sometimes the local rules and regulations actually challenged under the ISDS mechanism. The Bilcon case against Canada is a great requirement, right? Great example, apologies for misspeaking. So the idea there was that, well, Bilcon challenged exactly the process of environmental impact assessment and brought in the idea that core community values concept, which was part of the Canadian law, that was actually not, well, legitimate concept that should be challenged under the minimum standard of treatment under back then NAFTA. So that's just a reality of investment arbitration practice. So to my mind, when I speak about the added value of investment screening mechanism, I actually think it's a very powerful mechanism. Why is it so powerful? Well, the reason for it is that it is a type of a control mechanism, right? Who can have access to what, whether the particular investment can be established in the particular jurisdiction, whether this investment can be, well, eligible for further investment protection under the ISDS mechanism. And to my mind, that should come as a privilege, not as an absolute right. If certain investments meet certain criteria under the screening mechanism, while in this case, they should be eligible for example, ISDS protection. And we usually, well, the governments are usually quite flexible when it comes to the issue of national security, and they're ready to say it's self-judging, they're ready to include all the kinds of language. With sustainability and environment, I feel like it's almost, well, this idea that those are, well, protectionist, right? It's not something that we should fundamentally use to inform not only the language in the treaties, not only in language in the mechanism as they drafted, but fundamentally, I think this is a wrong approach. Presumably, if we want to actually save the planet and care about, well, environmental concerns, as we claim we do, right? I'm speaking specifically about, well, the European governments and the government of Canada, especially with the CETA preamble that was very beautifully drafted, but could have had a little bit more teeth when it comes to well, screening on sustainability and environmental grounds, for example. Thank you.
Well, thank you very much. Just to inform our audience that Sarah had to leave, so it's just the four of us for the last round of questions. Only the braves, or it depends, as lawyers would say. So I think Ksenia did highlight an interesting point in saying that this screening mechanism, they really are powerful mechanism. And at this point, I was wondering what could be the consequences, especially I'm thinking in negative terms, of expanding this kind of screening mechanism. I would say too much. I would think of the effect, possible downside shortcomings, both at the domestic level and on the investment system as a whole. Especially, I was thinking, are there any potential abuses that these screening mechanisms are like to trigger or to exacerbate? Say, for example, if an investor is coming from a geopolitical antagonist of the country he or she is seeking to invest into, or what about those investments in fields that are not particularly welcomed anymore? And I think I will use this opportunity also to pick up a question from the public, which is about target screening mechanism for target investment made by state-owned enterprises. So are these type of investment are going to be subjected to a special treatment? Are they going to generate any form of abuse, or they're going to be treated, I would say, fairly regardless of the state-owned enterprise qualification attached to it? I think, Ksenia, I would like to start with you, and then Kilian, and then Agata.
Thank you very much for this. I actually think we need to be very careful whenever we speak about any type of abuse in any kind of system. I think any kind of provision, however well it's drafted, can be a subject to some sort of abuse, right? So whenever we look at the historical examples, for example, interpreting fair and equitable treatment requirements or full security and protection standards, some can argue that, well, the expansive language of interpretation was a kind of abuse, right? So I think that it's important to understand that the screening mechanisms, if they're way too expansive, they also can be abused. But it all, as always, depends on the specific language, on a specific sector, and also on the specific requirements in the treaty. And I trust that the policymakers, given the experience in the multilateral and bilateral negotiations, can get this right. But the question, though, is about the priorities and the values that go into informing those mechanisms. So if we care about sustainability, if we care about security, for example, or if we care about anything else, right, that has to be sort of properly framed and drafted and included as a way to control what kinds of investments can be, for investment projects, for example, can be established in a particular jurisdiction. And that should be a part of a broader sort of conversation of what kind of international investment law future we want. So here, the screening mechanism for investments can be a very, again, powerful tool to get that future actually, well, to happen, right? So that would be kind of my perspective. With respect to the state-owned investments and the screening for that, it's a really good question, but I think here it would actually depend on the sector, right? Because those types of investments always get some sort of special treatment. I'm not an expert on that, but to my mind, there can be certain carve-outs for it. even under the screening mechanism, certain specific requirements that those types of investors will need to satisfy with those types of investment projects. But that's my take on it. Thank you.
Yeah, Kilian, you can.
Yeah.
Go.
Thank you very much. With respect to the negative consequences of constantly expanding security screening mechanisms in terms of scope, kind of transaction are undergoing screening, but also in terms of the standard of review, where we can see that the notion of security is also somewhat getting broader and broader, away from solely defense industries towards or over critical infrastructures and towards what has been framed as economic security. So this could become problematic also in the context of international investment law, and combined with screening mechanisms that do apply to existing investments, such as investment expansions or forms of call-in screenings and retroactive screenings. So this might be problematic in this context, but states do also in their international investment relations take into account their domestic screening policies, and those states which have enacted screening legislation already decades ago have also included in their treaties certain mechanisms, safeguard mechanisms, to take account of the screening policies. Especially in Australian or Canadian treaties, we do find carve-outs and reservations by which way these states do exclude decisions taken under screening mechanisms are excluded from the dispute settlement mechanism, both ISDS and also state-to-state dispute settlement mechanism. For instance, Canada has in all the treaties rather broadly excluded decisions on acquisitions and establishment. This has been an issue in this Global Telecom versus Canada case as well. In new treaties, Canada expressly excludes decisions taken under the Investment Canada Act, and also the United Kingdom in their accession protocol to the CPTPP has excluded decisions taken under the National Security and Investment Act from the scope of dispute settlement. But another form which we can see is also an extension of security exception clauses in those recent treaties, which usually include security exceptions. We find much more elaborated approaches, for instance, in the EU-Singapore Investment Protection Agreement. In Article 4.5, it's also stated, or the critical protection of critical public infrastructure, such as communications, power, or water infrastructure from deliberate attempts to disable or disrupt it, is stated as an essential security interest. In the Indian model BIT, we can see that it goes a step further. It also includes security clearance requirements. But apart from this extension of the notion of security, we can also see more elaborate attempts of states to secure self-judging language, which thus far has not been accepted by any arbitral tribunal or a dispute resolution body. Nevertheless, for instance, also the United States or India in recent treaties include in an annex or in footnotes that the invocation of the security exception clause shall not be subject to review by any dispute settlement body, which might be problematic. Nevertheless, I would say that a tribunal would still undertake a good faith review whether the measure is linked to the alleged security interest. In the context of economic security, the distinction might be very difficult. There has been one case under the GATT 1947, or a discussion, not a case, in the 70s where Sweden has adopted import quota for certain products for the production of shoes, for instance, and has referred to the decrease in domestic production, which has become a critical threat to emergency planning of Sweden's economic defense. Several other states have expressed their concerns, and eventually this import quota for shoe imports has been lifted. Nevertheless, in more recent times, and with geoeconomic developments and technological developments, a distinction between security and economic security interests, supply chains, etc., might be much more difficult. in the end, I would say that we can see under WTO dispute settlement, but also by the ICJ and by arbitral tribunals, that at least to some extent in international dispute settlement, a good faith review of measures adopted for security reasons is possible, and which shall of course function as a way to prevent discriminatory and arbitrary treatment, especially if a measure is disguised under the notion of security and shall rather exclude certain investors, for instance, because they origin from a geoeconomic competitor of that state.
I'll take it on. Nothing that I will say is in any way original. I think the consequences of expanding, the bad consequences of expanding investment screening mechanisms, however we call them, it's a conversation as so many in international investment law that it can appear somehow binary, even though it's not. It's more nuanced than most. On the one hand, we talk about the screening mechanism being used as a trump card. So this idea that if, especially if the screening is ongoing, so also applies to post-investment phase, that the states would start turning around and changing their regulations left, right, and center. We know that that's not necessarily true. On the other hand, we are also experiencing lower than necessary levels of foreign direct investment at the moment, especially greenfield investments, and there is a question of whether more and more of those screening mechanisms would slow down this investment. Here, I would perhaps argue to the counterintuitive and say, well, if more states did have screening mechanisms, it would level itself out, that it would have just been expected. And I think this is a conversation which in environment we still are very loyal to the idea of borders. That doesn't necessarily apply to environmental concerns. One thing I would echo what Ksenia was saying about the drafting and using the experienced negotiators, because environmental concern, what is an environmental concern? Well, how long is a piece of string? Anything can be an environmental concern, especially once you start framing it in various ways. So I think here, whatever we are advocating for needs to be drafted in a very tight way, in a way that still allows a level of nuance, but perhaps not every regulation can then be turned around and say, well, no longer falling under what we would consider to be well screened or worthy of investing.
Well, thank you. It's time for us to wrap up. So I will just share one last question from the public that is about what is the relationship between inbound FDI screening and outbound FDI screening. The attendees referring to the US move, but I think you're free to take it broadly. My only request is in this final round of comments, please just keep them short because we're really running out of time. So thank you. Who would like to start? Kilian, since you're, be a gentleman.
Thank you very much. Just very briefly on the issue of outbound investment screening, which we can see for the first time in the executive order by President Joe Biden in the United States on certain thus far very limited fields on to so-called countries of concern. The EU is considering a similar approach and has in its economic security strategy at least referred to that this will be debated, and there might be a proposal or initiative at the end of this year. I would say that the objective behind that might be or clearly related to inbound investment screening, but could also extend to other issues in the context of the environment of human rights. But I would say that the initiative of the EU should be awaited for that. Also, I would refer to Sarah, who's unfortunately not with us anymore, but to her publications on that, since I think she's the expert on outbound investment security screening.
Any Agata?
I can just add maybe briefly that fundamentally what typically we talk about when we discuss screening mechanisms, that's for inbound rather than outbound investments. But I think that, you know, looking at what's happening in the United States and the possibility that Donald Trump might win the elections in the future, we might see more sort of protectionist requirements imposed. So that's just a political reality. It has nothing to do, I guess, with the trends in international investment law more generally, but rather specific actors and their approaches given the political environment.
On the outbound, I do defer to Sarah as well. I think it would be interesting to combine the two questions on state-owned enterprises and on the outbound. I imagine that there would be a connection there, but I can only really echo what Kilian and Ksenia have said on this.
Seems that we need another conversation for that topic. So stay tuned, you never know. So thank you very much to Agata, Kilian, Ksenia, and Sarah for joining us today. It was a pleasure listening to your comments, presentation. I learned a lot, and I hope our audience too. So thank you very much on behalf of SIEL for being with us today. Let me remind you once again about the next SIEL conversation that will take place in November the 28th. I send a link for those attending. For those who are going to view a recording of this conversation, keep an eye on our website and you will find the registration link. Remember also the annual general meeting of SIEL, which is scheduled for December the 7th. And remember also to join SIEL if you haven't done so already. We very much look forward to welcoming you into our society. So thank you very much. I wish you a very pleasant weekend since it's Friday. And again, thank you very much to our panelists for joining us. It's been a pleasure. Bye-bye.
Thank you.
Thank you. Goodbye.
Goodbye.
Thank you. Bye.